on her client. She was going to join because we have the code defendant.
She's on.
Right.
Okay.
I've got the waiver and everything, so I don't know if you want to go ahead and handle that one first.
Oh, she's not on the calendar?
No, the code defendant.
Oh, but now we've got a lawyer for Ms. Young,
Right.
which is
Just
great.
wanted to touch base with you.
Okay, fantastic. Thank you. All right, we are about ready. Just got to pull up one other system here. Get that. All right, good morning, everyone. We've got a plea and arraignment calendar that we will bop through, I think, pretty quickly. And then at 9:30, we have a motions hearing that is going to be a little truncated, but we'll still talk about some of it. Our first position is Dwight Belcher. Is Mr. Belcher here? Hello, Mr. Belcher. Are you going to, Ms. Wood will be handling it, but your office will be handling it.
So we have Denzel Furlough.
Oh,
Well, actually, I know the calendar does say Ms. Wood, but we already have one of them. I did speak with him briefly to explain that to him.
okay. So Furlough, you represent. We've got Ms. Mignot on. Good morning, ma'am.
Good morning, Your Honor.
You recently filed an entry of appearance for Raven Young, which is great. Ms. Young has come to court a number of times. She's not here today. She wasn't on the calendar, but her co-defendant is here. Mr. Jordan, the prosecutor, had indicated in the past that Ms. Young's part of this case might well be resolvable if only there was a lawyer he could talk to. So if you, did you end up, I know you filed an entry because I see your name in the docket now. Let me see. So I guess if you could reach out to Ms. Young, she hasn't been arraigned. She's been on 3 arraignment calendars starting back in December. She was originally listed as having Ms. Bryant as her attorney, meaning a conflict defender. We all know why that could not become Eric Johnson, but you are now Ms. Young's attorney. And I guess what we need to do is figure out how you can get discovery. We'd need to either arraign Ms. Young directly, or you could waive arraignment on her behalf.
I'm going to waive on her behalf, Your Honor, so that we can move this matter expeditiously.
Great. I will have, if she has not already, have Ms. Nelson send you, Ms. Mignot, a waiver of arraignment form. You can fill that out. We'll get that e-filed. That'll get a scheduling order, and Ms. Young's part of the case can move along.
And Ms. Nelson has been very efficient, Judge. She sent it and it was executed yesterday and sent back to her.
Oh, excellent. All right. So it'll hit the docket probably today. Great. If you and Mr. Jordan can talk about Ms. Young's case at some point, we'll see what can happen there. Did you have anything else on the calendar, or were you just coming in because of the connection to Mr. Belcher?
Just the connection to Mr. Belcher and Ms. Young being now having counsel, Judge.
Okay. Thank you so
and
much.
To waive the arraignment and to
waive. Yep. Great. Then you are done. Have a great weekend.
Thank you, Judge. You do the same.
All right. So, Mr. Belcher, I'm sorry to keep you standing there, but I wanted to try to grab all these pieces. So, Ms. Feely, Mr. Furlough's in custody. I think that's right. Well, I don't mean to make you guess. I can find out. He's right here.
Good morning, Judge.
Hello. Hey, there's Ms. Wood. Holy moly. Hey, Ms. Wood.
How are you?
Well, the real question is, how are you?
I'm tired of being sick, but today's my last day of quarantine. So
excellent.
He is in custody, Judge. I don't know if you recall, he was the guy who was in Henry County for a really long time. We now have him in Fulton. Mr. Jordan and I are working. There's an additional case. I don't know if I've submitted the waiver of indictment, but I will get that to Mr. Jordan. We're going to try to wrap that up with this one.
Fantastic. Good. Well, that leaves poor Mr. Belcher. He needs a lawyer. That is a C3 issue. So I will flag this. Though really, am I the one who flags it, or does the public defender's office flag it?
I can contact Mr. Haddad.
Okay, that would be great so that he could pass it across. Mr. Belcher, are you going to need a lawyer appointed, or were you planning on hiring your own lawyer? Okay, we'll make that happen. I need to caution you that all counties in Georgia, but Fulton in particular, all counties are struggling to get these conflict lawyers, and conflict just means the public defender, they can only represent one defendant in a case, and they already represent Mr. Furlow. And because they've been talking with Mr. Furlow, they can't talk with you. And so we need to get you, you've got a right to a lawyer and you will get one. It may take a little bit because there is a shortage of what we call conflict lawyers. Let me make sure we've got good info on you because it's taken a while to get you here. So I've got an address in Decatur, King Glen Trail. That's the right street. Good. We know how to reach you. There was a lawyer named Ms. Luncheon, whose name is here. She has stopped practicing criminal law, I think. And that may be one of the issues. Because way back in 2020, you were in court and you got a bond. Let's see what name is here. Right. So Ms. Luncheon represented you as a conflict lawyer, or had you hired her? Okay, so she was appointed to represent you as a conflict lawyer. She has since, here's her motion to withdraw. Right, she doesn't practice criminal law anymore. And so I let her withdraw and we need to get you a new lawyer. You remain on bond. It sounds like you've been complying with, well, I don't know, you missed court, but I set aside the bench warrant. You came to court. Okay. I don't know, maybe wires got crossed, but you came to court at the end of about a month ago. So I lifted the bench warrant. We've got the good address for you, and we will get notice to you when we get a lawyer lined up. I don't want to make you come back here only for you and me to look at each other and like, hey, you have a lawyer? No, I don't have a lawyer either. But it may take a little bit, and that's probably frustrating because these charges are from almost 3 years ago, and I'm confident you're trying to move in your own direction. Do you have any questions about anything I talked about? Who did you bring with you? Okay. We'll get something to your address. You're welcome to call my chambers if it's been a while and you know what's going on. Let me see if there's anything in particular about your bond.
Actually, I do have a question on information.
You may.
So, I have outside, because originally it was Judge Pope who set the conditions for my bond.
I'm looking at the bond right now. Judge Pope in October of 2020, so 2.5 years ago.
Sir, and I was on the condition that I could work, go to school, and go to church. But when I was fitted for my ankle monitor, I was told I was going to go work at home. But Judge Pope said that I could.
I'm reading it. It says you have a basically house arrest, 24-hour curfew, except for work. So you are able to go to work. Okay.
I go to church too, so
Your question is, can you also go to church?
because the day in court, she said that I would be able to go to work, school, and church. That's what she said.
Okay, but it didn't show up on the bond. Okay. Mr. Jordan, given that Mr. Belcher has been on bond with the same ankle monitor for 2.5 years, and we don't seem to have had any issues, do you have any objection to the bond being modified to allow Mr. Belcher to go to church and you go to school?
I'm enrolled in school, yes, sir.
Where are you enrolled?
And I'm metropolitan.
What are you studying?
Sir.
What are you studying? Okay. And what is the job that you have?
Currently, I work with Mavis Science Bridge right now.
Okay. But not from home. You got to go to Mavis. That's your job. You also go to school and well, I guess you've been going to school, and you want to go to church and not worry that you're violating your curfew. Okay. Mr. Jordan, any issue with me modifying the bond? I'd be inclined to just take the ankle monitor off, but it's a little odd that Mr. Belcher and I are even talking because he doesn't have a lawyer. So I'm going to take baby steps and at least modify the curfew in that way.
State has no objection to that, Your Honor.
All right. Then I will modify the bond. I don't know how to get that to you, but you're hearing me say it. And I'm telling you that there'll be a new bond in that same dollar amount, everything doesn't change any of that. It just expands the exceptions to your curfew to include school and church. Does that work? Okay, great. Anything else? We'll work on getting a lawyer. You are free to go. All right, Kevin Rouse.
Mr. Rouse is here. I've spoken with him. He may be Ms. Woods. I filed a waiver and confirmed his address and got good contact information for him.
Okay, Mr. Jordan, anything on Mr. Rouse's case?
That is going to be me, Your Honor.
Hey, Ms. Willingham, how are you?
I'm well, and you?
All right, anything from the state on Mr. Rouse's case?
No, Your Honor.
Okay, then Mr. Rouse, I will enter a scheduling order that will set some deadlines. The first one is for Ms. Willingham, whose voice you heard, to get discovery to Ms. Wood, whose voice you also heard today. That's a colleague of Ms. Feely's. Once Ms. Wood has discovery, she'll meet with you to talk about how strong or weak the state's case looks. Maybe there'll be some motions she's going to file. If so, you'll need to come back to court to hear those motions. And then the next stop will be what we call final plea, which is the last stopping point where you could work the case out if you want to work it out, and still withdraw your plea if you don't like the sentence that you get. And I'm not saying that you're going to end up pleading guilty. It may be that the state says, oh, we need to dismiss, we got the wrong guy, but that's the natural flow of cases. Okay. Any questions? All right, Ms. Feely, anything else on behalf of Mr. Rouse?
Nope, he's good to go.
All right, thank you, sir. Ronald Rosario.
Judge, I filed a waiver for him last week and also updated his address. And I believe I received initial discovery, so we're good to go with a scheduling order.
How are we doing with Mr. Rosario? I don't see him here. Or did you tell him he didn't need to come because of the waiver?
I did, Judge, and I apologize. He was in New York when I talked to him, so that's why I filed the waiver.
Okay, that's fine. As long as you said he doesn't need to be here, as opposed to, gosh, you're not sure why he's here either. It just, given the charges, I want to make sure he's not hard to find.
Yes, and I got updated contact for him, and Miss Nelson got his new address as well. So
okay, sounds good.
thank you.
Number 4, Kanisha Smith.
I don't have any information on her, but I did note that this is February 23rd, 2020 incident date.
Ms. Willingham, your case or Mr. Jordan's?
That is going to be Mr. Jordan.
Yes, Your Honor, that's my case.
All right, let me look at the file. Interesting. Mr. Wright, Derek Wright filed an entry of appearance back in 2020, and there's no withdrawal, but it lists your office as counsel. Okay, Mr. Jordan, your thoughts?
Your Honor, given the length of time it's been, I wouldn't, the state wouldn't be opposed to one reset just for, to see if contact can be made, and especially given it's 3 years from the incident date to the actual filing, if Your Honor would permit that.
Sure, and maybe we can reach out to Mr. Wright as well to see, maybe he has contact. So, Derek Wright, one reset. Okay, and then I'm going to do a bench warrant, I guess, at that point. It would get the bonding company to do what it does. You know, Mr. Jordan, there are a couple of divisions. I know you're leaving here, but maybe Mr. Peoples will resurrect this age-old practice of seeking bond forfeitures.
Mhm.
And lo and behold, the bonding company shows up at the bond forfeiture hearing with the defendant because they don't want to cough up the money.
Yes, Your Honor.
All right. Well, we'll see if Ms. Smith can be found. And finally, we've got Antonio Edie.
He similarly had a private attorney listed in 2020.
I believe I received a waiver for that, Your Honor.
Hold on. Yes, look at that. Randy Williams filed a waiver. Okay, so we'll do a scheduling order for Mr. Edie. Okay. So we'll modify Mr. Belcher's bond. He needs a lawyer. Rouse waived. Rosario waived. We'll reach out to Mr. Wright on Ms. Smith, and Edie waived. Anything else, Mr. Jordan or Ms. Willingham, for this morning?
No, Your Honor.
Nothing from the state, Your Honor.
Mr. Jordan, what's the latest on how the trial calendar will be navigated for the cases that have your name on them?
Your Honor, I am working with Deputy Mack to see if, because I don't, on the May 15th and May 16th, at least from my current knowledge, I don't have any court dates for the sexual assault unit, so I should be good to try the cases that I do have on the calendar. But I'll make sure that 88 Peoples accompanies me on the 8th, just in case that we need to swap.
Okay. And Ms. Willingham, I did get an email.
Yes, regarding Richardson.
Yeah. So you're going to do your best to get medical records.
I am.
Okay, and we'll see what happens. I don't have the trial calendar in front of me. I've got this feeling that cases keep dropping off of it. So I want to make sure we have something to try. And as long as we do, then it may be that we don't need to get to Mr. Richardson.
Yes, Judge.
Okay, but I appreciate the heads up.
Thank you.
All right. Well, we've covered everything in record time. Ma'am, you are here for what case?
I am here for Cornelius Mapu.
You're in the right place. That's supposed to start in about 7 minutes. Okay, and ma'am, were you here for a case? Yes, you.
Yes, I know he's not here today, I was trying to see possible remove Melanie and replace with Ms. Katie, because I'm not satisfied with his service. He's not responding to my text, phone calls, anything, I don't know what's going on.
So that's a Mr. Lloyd conversation to have. And when we next get him here, we can certainly talk about that. Okay.
It's supposed to be like the 8th, this week, I'm saying supplemental here, I don't know what that is.
Okay, I don't either. I look at the calendars the night before and see what's coming in, and then we get ready to go. So as long as you know when he'll next be here, then Mr. Melnick will need to be here. You and he can talk, and I can talk with Mr. Lloyd and Mr. Melnick. All right, thank you. All right, so we will sit tight for a few minutes. Let me see who's on. Ms. Jackson, I appreciate you joining us. We had no pleas this morning, regrettably. Our next hearing is a suppression hearing in a murder case, so we will not need pretrial services. You should get an early start to your Janet Jackson, Taylor Swift filled weekend.
Thank you, Judge. You enjoy your weekend as well.
I will. I'm staying out of downtown. Bye.
All right.
All right. So Ms. Rivers, we'll need you in about 5 minutes. Hopefully we get Mr. Abate and Mr. Hoover.
Okay, Judge. Good morning. Thank
Good
you.
morning. What did you send? Oh, thank you. It's not swerving out of your lane. I mean, someone was going to have to do it.
And I emailed Derek Wright as well, but the court may have better luck getting a response.
Yeah. Morning. Are you waiting on me?
Just, I think I'm finished. So.
You are? Yeah, no, you're free to go, but thank you for being here. Sounds like you get your partner back next week. You too.
Good morning.
Hey, how are you? All right, give me 1 second. We'll get on the record. Okay. Before we bring Mr. Muckle out, good morning, Mr. Abate and Mr. Hoover. Thank you both for being here. I received, when I got to work, not when it actually hit my inbox, Mr. Abate's email. It sounds like the state won't be in a position to go forward on one of the two motions. I'll call it the Daubert motion. I have a second motion, though, that I think we can still cover, which is Mr. Hoover's motion to suppress internet search history evidence. I don't think that involves experts or people explaining the science or technology behind anything. So I'd like to cover that if we can today, and then sort out, consistent with Mr. Hoover's schedule, when we can tackle the Daubert, the 702 motion, so that we can get Mr. Muckle's case on a trial calendar. Is that something you can do today, Mr. Abate?
Yes, sir.
Mr. Hoover, I'm gonna let you get on the record once your client's out here, any objections to that plan, but are you able to go forward in the way I described?
Yes, Your Honor, we are.
Okay, great. Do you need to speak with Mr. Muckle in private before we bring him out?
Just briefly. Yes.
Great. We'll get you back there, and then when you guys are ready, come on out. Mr. Hoover, are you ready for your client?
I will be in 2 seconds. Actually, yes, we can bring him out.
Okay, I'm not rushing you. If you need a minute, just let me know.
Yep, we're ready now.
Long knees, man. God. No, I feel good. This right here. Oh, yeah. Yeah, I'm sorry. I'm got the long legs. Got stretch.
All right, let's go on the record. This is 21 SC 177971, State versus Cornelius Muckle. Mr. Muckle is here in court with his lawyer, Mr. Hoover. The state's represented by Mr. Abate. Mr. Muckle is charged with 2 counts of murder and related offenses. We were today going to cover a couple of pretrial motions that Mr. Hoover had filed before Mr. Muckle was last on a trial calendar, and they were sufficiently substantive motions that we weren't able to go forward with Mr. Muckle's trial. We needed to set the motions down for a hearing. By my count, there are 2. There is a Rule 702 motion that challenges the admissibility of Google geofence information. I don't know that we're going to cover that today, but that's one of the motions. It's sort of a Daubert-esque motion. And the other is a motion to suppress internet search history evidence of Mr. Muckle's on I would call it relevance grounds, 401 and maybe 403. I don't know what the internet search history shows, but it would be a question of relevance versus prejudice, if it's relevant at all. Mr. Abate reached out to Mr. Hoover and to me and Ms. Nelson early this morning. I'm going to let him put on the record the issue he encountered, and then we'll get Mr. Hoover's response. I think at a minimum, we will be able to talk about the motion to suppress the internet search history evidence. And then before everyone goes, if that's all we do today, I'm going to try to extract a date out of Mr. Hoover so we can see when we can come back for the Daubert motion. And I think with rulings on those 2, then it's simply a question of whether we specially set it given Mr. Hoover's schedule or we find something on the calendar, but we can lock in a trial date for this matter. So, Mr. Abate, tell me what you want to get on the record concerning the state's preparedness for the 2 motions.
And I would start with, I apologize to the court and counsel. When I was going through what we.
Microphone, thank you.
Yes, ma'am, I apologize. I apologize to the court and counsel. When I first received the initial emails related to the potential dates for motions hearings, I had the second email that Ms. Nelson had sent with a possible date said the singular date of May 11th at 1 p.m. I neglected to see the email after that, in which she actually scheduled it for today, April 28th at 9:30 this morning. When I received the first email with the May 11th date, I'm one of those old school people who handwrite it in a calendar, and I don't typically pay attention to my Outlook calendar because my written calendar is usually accurate. Here, that is wholly untrue. It is at no fault to anyone other than the state. And because of that, I was looking over, some calendars in my Outlook email, and that's when I realized around 2 a.m. that this was scheduled for today. So the state would be requesting a reset date for the Daubert motion due to my miscalculating or incorrectly writing the date for today's hearing.
How long do you think that hearing would go? I know you don't speak for the cross-examination, but in thinking about the witness or witnesses that you'd present to meet the burden that you've got in a 702 hearing, how long would the state's presentation be?
I can't imagine the hearing lasting more than an hour, hour and a half, 90 minutes at most.
Okay. Mr. Hoover, I want you to get on the record your response to the request, but before that, if you could let me know in your experience, if you've had geofence challenges before. I have not. How long you found those to go?
I agree. It wouldn't last longer than 90 minutes.
Okay. So if we can find a 2-hour block in the near future that works for the 3 of us, that's enough time.
Yes, Your Honor.
Great. All right. I'm inclined to handle Mr. Abate's request that way because we'll make some progress today. But Mr. Hoover, I want you to get on the record your response.
Yes, Your Honor. In response to the state's position, we understand we can't go forward without the expert. As long as we're able to argue something today, and if we can get this on, just so I'll work with the court and with the state so we can make sure my schedule works. As long as we can get everything scheduled and get back on the trial calendar, there's no objection from us.
Okay, good. I appreciate your flexibility. I know you are advocating vigorously on behalf of Mr. Muckle, who has been in jail for a long time, awaiting some resolution to these charges. And we'll move in that direction today because we're going to cover your other motion. Why don't we dive into that? I've read it. I understand the theory behind it. I would analogy, you picked a great case, the boring, BORING, Georgia Supreme Court case with the satanic influences. I know recently our Supreme Court, the Georgia Supreme Court, opined further on this topic concerning, I'm not going to remember his name, but the person who was found guilty of his child's death because he left his child in the car. And that was the focus of the trial. And yet there were day after day of look at him online, looking at pictures of little kids. And the Supreme Court said, that's not what this case was about. And that didn't end well for the prosecution. So I want to make sure we get this right. But I have zero context. I don't know if the internet search history was for how to refinish furniture. Probably not all that relevant. Mr. Abate is very creative, and maybe if there was lacquer used to set the fire that's alleged here, then it might be relevant, but it's not going to be particularly prejudicial. So why don't you set the stage, Mr. Hoover, by letting me know the items that are of concern or the nature of those items. I think I understand the case law. I'm not precluding you from arguing that part, but let me know what it is that concerns you.
Yes, Your Honor. The biggest thing that concerns me is that in this case, the two victims are an elderly couple that were killed in their house, and the house was later set on fire. The specific evidence that we're discussing is basically internet search activity, for lack of a better word, deals with searching granny porn. There's been nothing that I've seen in the discovery that suggests that anything, there was no type of sexual activity that happened to these two elderly people, especially the woman. Basically, someone went in, strangled them, set the house on fire, and left. At the point where Mr. Muckle's search activity for porn, when there's no type of sexual anything at all that ever was even suggested in this case, I just don't believe it's relevant to anything other than Mr. Muckle's character at this point. Okay. And that's why we're asking to keep it out.
So your understanding of the autopsy of the female decedent, well, first, were the bodies in a condition where there could be a meaningful analysis that this fire, did it damage the deceased couple?
Well, we may differ on that. I'm going to say that I don't believe the bodies were that severely burned to where they couldn't do anything.
Okay.
Obviously, the state may take the position because it was a fire. It was, but I didn't see anything in the discovery or the autopsy or any of the reports that suggested that they couldn't do anything because the bodies were so burned.
Okay. And more to your point, there's nothing in the autopsy to suggest that the female decedent had been sexually assaulted in any way.
Correct.
Not that they necessarily were looking for that, but it was a strangulation death. And so injuries that would have been described would have been injuries to the throat or the neck or whatever.
That's correct, Your Honor. We haven't seen anything that suggests otherwise.
Okay. Then the subject matter of the internet search history, because people search for lots of things. There could be a search for fast food near me. The one that jump out at you that you're seeking to keep out are the ones that would be searches just based on the language used for pornographic images of elderly people.
Yes, Your Honor.
Got it. You use the phrase granny porn. Got it. Okay. Mr. Abate, is this moot because you don't plan on using it, or it's central to the state's theory? If so, how do you reconcile that with, and you're going to maybe be better with names, that recent Supreme Court case about the Cobb County?
Ross Harris.
Yes, Mr. Harris.
So, it's a moot issue. I'll be honest with the court. I don't intend to, I considered making an argument to the court that obviously the female victim in this case is what you would consider a elderly person, a granny. And she was strangled by some sort of, because due to the fact that they were able to determine, that there were ligature marks, which would prove that, and that she died from smoke inhalation, which would mean that she was burned alive, which it's a mood issue. I think it goes to his character. I will be frank with the court. I don't even think I can make a colorful argument to because I don't know whether the victim was sexually assaulted or not. It would be the state's position that both victims in this case, they were burned so bad that they wouldn't have been able to determine whether either were assaulted sexually or not.
Or just assaulted, period. There could have been bruises about the face or the torso because they were beaten. But you're saying the condition of the bodies when they were recovered was such that the medical examiner couldn't make any of those determinations.
Correct. And I'll, to be candid and frank with the court, would say there was evidence of sexual assault. There's no evidence to prove that she was sexually assaulted by this defendant. The fact that he likes to watch older people, have sex, I don't believe would then equate to him sexually assaulting an older person. So, and none of the porn that was watched by the defendant involved any sort of abuse to an elderly person. If that was the case, I think the evidence then would be incredibly relevant, and I would make the argument that it is probative and should be admitted during the trial of Mr. Muckle's case. But I believe that if I was to attempt to admit it, it would be for purposes that would make the case it would make issues that we don't need to make.
Okay. So I will enter an order just so we have paperwork addressing each thing that denies the motion as moot. But I'll make clear in there that's because the state has represented they don't intend to use that evidence. And I'll put in my usual language that says this is subject to change. Who knows what the defense is going to be if Mr. Muckle chooses to testify. Mr. Abate, if you think a door has opened that would make that evidence somehow relevant, we need to have a conversation about it, not just you conclude the door was opened and then you're starting to ask Mr. Muckle about what about these images and these searches? Because I'd want to give Mr. Hoover a chance to say, I don't think that was an opening, or here's why you shouldn't change that, Judge. But for now, based on Mr. Abate's representation that the state does not intend to use the results of, was this found on a phone? How do you have Mr. Muckle's internet search history?
It's from the Google evidence, or the evidence that was provided by Google.
Not geofence, which is location evidence, just warrants or subpoenas that were sent to Google that provided information that's linked to Mr. Muckle through a user ID, an account, something like that.
That's correct.
Okay, and that gave you internet search history. That gave Mr. Hoover some concerns, and it sounds like the concerns were understandable, but now are moot because the state's not going to move forward with that evidence, absent reopening the issue outside the presence of the jury.
Correct. And just for the record is clear, in your honor, is fully aware of the state intends to use some of his internet searches, not the internet searches that pertains to granny porn, but other searches that the defendant made. The state contends are wholly relevant and related to the issues and the facts of this case.
So assuming you lay a proper foundation, you're free to attempt to tender anything that doesn't fall into this subject category. Mr. Hoover's not waiving relevance objections. He's just, it sounds like that other material, he's comfortable objecting to relevance in front of the jury. The cat's out of the bag if the question is asked, so Mr. Muckle or Agent so-and-so, what is grannyporn.com? That's it's hard to unwind that one. So Mr. Hoover, we could treat as a motion in limine if you and Mr. Abate are getting closer to trial and Mr. Abate chooses to share with you, these are the searches we are going to explore with an officer. And you think those aren't relevant, but you're concerned about the prejudicial impact of even hearing the fact that a search like that was made. Let's just do a motion and eliminate. We've set up the framework to analyze it. You did in your motion, but it sounds like the evidence that would be most inflammatory, you flagged, and we have now put in a safe space unless and until Mr. Abate says, wait, we need to revisit that. Does that work for you?
It does, yes, Your Honor.
Okay, good. Are there discovery issues we should talk about now since we have everyone here in court? You've got, I believe you've got everything. I know there were, that was voluminous and there were some things that were still trickling in, but I think we've passed that point.
Yes, Your Honor, that's correct. We have everything now.
Okay. So other than ruling on whether the geofence evidence comes in, we should be trial ready. Mr. Abate, do you have people coming in from out of town such that a trial date is a complicated thing? Or is it more Mr. Hoover's schedule that's going to be what we need to consult with?
There are the family members of the victims, they are out of town, but I think we can work, those issues will be much easier to work through. I think Mr. Hoover's his schedule and the fact that he's as busy as he is, I think is more the concern.
Okay. The geofence, if we're not going to get substantive today, but it'll just help me be more prepared. This is basically how a technology company can first tell you a device was in a location, or maybe the same device was in two different locations at these times, but it's anonymized. And then eventually, if there's an adequate showing, Google de-anonymizes to the point where they say a device with either this IP address or this phone number was in or near this area at a particular time. Is that a sort of crude simplification of what you would be using geofence evidence for?
That's correct, Judge.
Okay, and is that what is concerning you? It's the technology behind that? Because if we're talking about two different things, I want to make sure, thank you, we don't get to the hearing and they're like, oh, wait, that's what you're going to do? I don't need you to get an expert for that.
Well, it's not just what Google and their algorithm and the information that they create it's also who the state plans on bringing this evidence in.
Okay.
So there's two parts to it.
All right. You say algorithm. Normally when people say Google and their algorithm, that's the search engine. So I type in furniture refinishing and Google gets the things most relevant to that inquiry. That's their world famous algorithm. I'm not aware of an algorithm so much as literally signal collection. So it's more technical.
True.
And less murky when we're talking about geofence, because it's simply saying, yes, this thing is transmitting a signal in this area.
True. Algorithm is probably the wrong word.
Okay, but then we're talking about the same thing at least. You gave it a different label. We'll call it whatever. We'll agree on a term for it. But I appreciate your second point. I think that's what I took more from having read your motion is, one, the state needs to show that geofence is reliable technology. And maybe that's not the right name for it, meaning geofence, but it's a technology that is saying this device is in this area at this time. But just as important, who is it who is translating all this? Because it's a bunch of, it looks like distance measurements, it's degrees, inches, feet, that kind of thing. But who is it who's translating this information to say, well, I can tell you what this technology is saying. It's saying that this device with phone number 1234 was in this location, and somehow phone number 1234 is linked to Mr. Muckle to make it relevant. And you're entitled to know who's going to be talking about it. So it's not someone who simply got a script from Google and is reading that script back.
Yes.
Okay. All right. Well, Mr. Abate knows what he needs to do then to satisfy 702 at that hearing. Ms. Nelson just handed me a few dates and times that I would like to bounce off your schedule. Let's see here.
And just so everybody knows that the person I'll be intending to, I guess, present to talk about how the, you know, how the information is translated, who processed, you know, the information to show exactly what we believe it shows would be Kevin Leonpacker,
Okay.
from the Atlanta Police Department.
And is he the person who would testify at trial also?
Yes.
Okay. All right.
And then as to that, the actual records, the state's contention, they come in under 803 as, you know, certified business records.
I don't think that was so much the challenge about the business records. It's translating them. You know, phone records are easier to translate. This number called that number on this date at that time. And usually the only wrinkle is, oh, but that's Greenwich Mean Time. So I need to adjust it by subtracting 5 hours or adding 5 hours. It may be that the geofence data is more opaque. And so I think the defense is entitled to hear who is dealing with that opacity.
Yes, sir.
All right, dates, possible dates. May 12th in the afternoon. How is that's another Friday. So Friday is 2 weeks from today.
That works for me.
Let's lock it. Well, Mr. Abate, you can make that work. You'll get Leonpacker from leave if he's on leave.
Yes.
Okay, 2 o'clock on May 12th, and we'll do a calendar. So it's, I don't know what we need to do for Mr. Abate, but we'll do a calendar for you, Mr. Hoover. But if you put it on your calendar, May 12th, 2 p.m., we'll have Mr. Muckle over here again. We'll work through that, and that ought to remove the last hurdle from getting Mr. Muckle's case on a trial calendar. Mr. Muckle, do you have any questions for me about process?
No, sir, Your Honor. I think it was all covered.
Okay. Well, I will see you in 2 weeks, along with your lawyer, the prosecutor, and at least one witness for the state, and we will go over that other motion. As mentioned, I'll enter an order today on the motion to suppress the internet search, summarizing what we discussed. So it's in the record. Anything else, Mr. Abate?
The state, we filed a 404B motion. I don't have, to be candid with the court, a real additional substantive argument to make to your honor or to counsel. I would submit on the motion and the brief that I filed with the 404B motion. But if we want to take it up, if any argument needs to be made, we can take it up to 12th. It would be a very quick exercise.
Why can we not do it now?
We can do it now.
We should. And full credit to Ms. Nelson. She wrote 404B on here. But the motions, when I'm poking around, I found Mr. Hoover's 2 motions. So let me find this.
Oh yeah, we'll talk about that. Yeah. That's just it. They're not saying it's real, but they're saying it's an officer. That's an expert in it. So we're gonna argue all that on the 12th to keep that out. Give me 1 second.
So we've got one other also. I just saw it's a motion, and we'll just talk about it later. The motion to eliminate about the prejudicial identification of victims, but we can do that on the eve of trial. All right. So the 404B, it's 99 pages long. I assume that's because of police reports.
Yes, Judge.
Okay.
Oh yeah, I know.
All right, the first few pages of the motion are printing out, but let me summarize what I understand the state's trying to do. The state has filed notice to admit at trial evidence of other acts of Mr. Muckle that consist of 4 burglaries, one from '02 in Douglas County, and the other 3 are in Cobb County, 2 from '09 and 1 from 2011. And the theory is, it sounds like primarily motive. You provide a laundry list, but I don't think identity would do it, because none of the other burglaries involve setting something on fire or strangling anyone. In fact, a couple of them were, well, all of them were commercial. They were businesses rather than someone's home, but they involved entering a structure to commit a theft. And that is connected to the allegations in this case because the deceased, the Hubbards, their home appeared unoccupied. All the windows were open because their air conditioning had stopped working, and someone entered their house and ended up strangling them, setting the house on fire. So that's a burglary. Let me ask a question of you, Mr. Abate, then I'll let you argue what you want to argue and explain to me how you'll be proving up the 4. It may be there are 4 convictions. Was there any evidence that anything was taken from the Hubbard's house, or because of the fire, it's impossible to know?
Yes, Judge. So that's the main reason why the state filed the 404B motion. I would agree with the court how you characterize the 4 similar transactions that the state is attempting to admit during the trial of Mr. Muckle's case. That is correct that they are all commercial burglaries. So that is, I guess, the one distinction between that and what occurred on July 18th. July 3rd, 2018. The evidence would show is that both of the victims wore jewelry very regularly that they didn't take off ever, is the understanding and the testimony that would come from members of the family. Upon them being found and burned, they didn't have that jewelry on. And what the evidence would show is that 2 days after, and then and again a few days after the arson and the deaths of both victims in this case, Mr. Muckle is pawning jewelry at several different pawn shops here in Atlanta, one being off of Delow Road and another pawn shop off of Piedmont Road right before you get into the area of Lindbergh. So that would be the way the state would be proving up or making relevant and the evidence probative as it relates to those 4 burglaries and the state's case in chief here in this case, Your Honor.
Couple questions. Was any of the jewelry that was pawned the Hubbard's jewelry, or the evidence is just that Mr. Muckle was pawning jewelry? So
the testimony and the evidence that was presented at trial would be the descriptions of the jewelry that was pawned at these pawn shops. Family members of the victims would be able to describe the jewelry that the both victims wore regularly, and that they would they are identical, almost identical, or they are very similar to the descriptions that the pawn shops write on the pawn ticket. What I can say to the court, due to, I guess, the length of time it took for Google to provide the results for the geofence that was requested or done by search warrant at that time, and when that evidence through the geofence became, we became aware of that evidence. The pawn shops had either the jewelry had been sold, the jewelry had been destroyed because it had not been sold for a period of time, and they're not required to take photographs of the jewelry.
Okay, so for the passage of time reason, the jewelry wasn't recovered. Pawn shops destroy jewelry if they can't sell it?
I guess all pawn shops are owned by a parent company, and it's the parent, they send the jewelry to the parent company, who then they melt it down or, use and then sell whatever's made from that.
Okay. How would you be proving up the 4 burglaries?
So the 4 burglaries that the state provided in its notice, the defendant was convicted of all 4 of those offenses. So there are, I would have certified convictions to present to the court and the jury if Your Honor was to allow the evidence to be admitted. I'd also likely bring in, if this would be all law enforcement, I would bring in 1 law enforcement officer from each one of the incidences, and where they would describe, what they observed, what they responded to, and who they arrested. It would be very not like we previously experienced in a previous case with Mr. Goolsby.
Okay. Was there any evidence in any of the other 4 burglaries that Mr. Muckle was pawning things that he took, or fencing in some way, selling things that he took from any of these 4 businesses?
No, Your Honor.
That's not how he was caught, or that evidence wasn't developed?
That evidence was not developed. He was, in each one of the instances, he was caught very quickly in time to when they were dispatched or made aware of the burglaries.
Okay. So I didn't mean to put words in your mouth. In terms of the purpose or purposes, again, you put a list of motive, opportunity, intent, et cetera. What would you articulate as the primary purpose or purposes of admitting 1 or more of these burglaries?
I had erased the kitchen sink, and it would just be motive, Your Honor.
Okay, got it. All right, and tell me why you think that letting in 1 or more of these would not be unduly prejudicial.
As Your Honor is aware, Rule 404B it's a rule of inclusion, and the courts are to weigh the evidence in a way that in the spirit that the evidence is admissible and should come in. What I would submit to Your Honor is that because due to the similarities of the, I guess, modus operandi, or the heart of what's occurring, whether it's a commercial burglary or residential burglary, items are being taken, and the state would be able to prove that items were taken in this instance. And I would submit to the court that those are instances that are, probative. They're more probative than they are prejudicial to the defendant, in the sense that it's not as if we're bringing in, violent offenses or offenses that would shock and awe the jurors and be used for that purpose. The state would submit to the court that the sole purpose of bringing in this evidence is motive, and the state would submit to the court it's a necessity to bring in due to the fact that the evidence that puts the defendant on the crime scene is the geofence, and what was then, I guess, articulated or they were able to determine from the geofence is that items were then, the defendant was then pawning items very soon after the incident, making it very probative or similar to the fact that a burglary was also committed during this instance.
Okay, got it. Mr. Hoover, your thoughts about the 404B notice?
Yes, Your Honor. To start, The court and the state have already touched on it. However, I'd say the notice the state gave us is it's basically insufficient at this point. And I'd like to say it's because the state literally just threw the laundry list of, I'm going to use all of these reasons, not specifying which ones.
Well, but I would agree, which is why I pressed Mr. Abate, and he has said, discard the laundry list, it's motive. I have to rule on a purpose or purposes, and I always ask the state, because typically the state will say, if not even a whole laundry list, they'll say motive and other purposes. Well, my ruling would be purpose specific. If I'm going to let it in, it would be for this purpose or these purposes, full stop. Unless it's 414, 413, and then use it for whatever they want.
Yes.
Not so with 404B. So I have heard Mr. Abate refining the notice. And so if you are saying I object because it's deficient notice because I need more time, I'll respect that and you can respond later. But I think that Mr. Abate has now cabined it to motive. Judge, we want you to let it in because it goes to motive. Why would Mr. Muckle have gone into this house? Because he's a burglar. I'm distilling it, but that's basically what the state's asking for.
Yes, Your Honor. And I just want to make sure that it's clear on the record. I'm not saying that I need more time. I'm just saying the state's notice up until now, where we have the luxury of now knowing it's not motive and everything else. I'm saying for that particular reason, I want to say the notice is improper.
Okay.
And I have two cases I'd like to put on the record for that position.
Okay.
The first is Rodriguez v. State, RODRIGUEZ v. State, and that's a 211 Georgia App 256, a 1993 case. And the other is Sampson v. State, SAMPSON v. State. That's 980 F2D 883. That's a Third Circuit 1992 case. And basically what those cases stand for is a simple recitation of all of the permissible purposes will not suffice. Proper notice when it comes from the state. They must particularize it as to what they're actually going to use the 404B or any of the priors for. The cases also say that it's not the duty of the defendant to guess the purpose for the state's proper or proffer transactions. It is not the duty of the court to select for the state what a proper purpose is. Again, those cases basically say the state can't just throw the entire laundry list down and then the court and the defense has to prepare for everything. And then the state comes in, oh no, we just meant this one part. So I just want to make sure that's clear on the record that we're saying the notice is improper and all of it should be thrown out specifically because of that reason.
Can you give me the second case, Sampson? You said 980 F second, but I didn't get the remaining digits.
883.
Great, thank you.
And that's a Third Circuit 1992 case.
Yep. Okay. I don't disagree with that principle. I know that I will typically push back in the 404B hearing if I see the laundry list, because I guess in theory, there could be a magic other act where it actually is identity and intent. But we certainly need to refine it. And my order, if I'm letting it in, will have to specify for what purpose or purposes it would be admitted. But your concern is well taken. I think we've cleared that hurdle given the refinement, the oral refinement that Mr. Abate offered.
Thank you, Your Honor. And now moving forward with the actual priors the state's trying to get in, obviously under 404B, they have to prove that the independent offenses were committed by my client, which obviously don't have an issue with that, that they're relevant to some other issue other than character, and that the probative value is substantially outweighed by undue prejudice. Now, Your Honor, when the court looks at the priors, the court doesn't just focus on the similarities between the priors and the case in chief. The court also focuses on the dissimilarity. They focus on the time, and I think the court got into it when it asked about was anything pawned or was a jewelry taken or how was it done? So, Your Honor, I want to just delve into the actual priors themselves since the state has not yet. In regards to the first one, which is the Douglas County case from July 18, 2002, that was a burglary of a convenience store. And Your Honor, in that store, 44 cartons of cigarettes were taken. There was evidence that the front door was busted in with a rock, and 2 males were seen on surveillance they were saw by the cops and later dropped the cigarettes when they took off running. Nothing in regards to this case in Douglas County from 2002 has any similarities to what happened in our case in chief. I'd first like to start out that this case is I have it somewhere, or I'll get it in a second. I first like started that, Your Honor, the evidence in the first case from Douglas County says that there were two males that went into a surveillance door and they basically threw a rock through her front door. We don't have that situation here. It's my position that the state doesn't know how many people actually went into the house in our case in chief. They just know that there were devices that were located in the area, and there were more than one device, but officers didn't go after all of the devices. They only went after a specific one. Furthermore, when it comes to the items that were taken, Your Honor, you have to look at that. These are literally cigarettes. You're not pawning cigarettes. You're not, I mean, you may sell cigarettes, but there's not even evidence of that. Two people went in there, broke into a gas station and stole cigarettes out. The only thing that this first case would go towards would be Mr. Muckle's character of, like you kind of said already, he burglarizes stuff, he breaks into stuff. Furthermore, Your Honor, this isn't a residence. It's not an apartment building. It's not a house. It's not a townhome. It's a business. That alone shows that, and I will be quoting cases later in my argument that shows that for that reason alone, this similar shouldn't be in. But if you look at all of the circumstances surrounding this prior in Douglas County from July 18, 2002, the only thing that the state can use this for is to show, look, he's been doing this as far back as 2002. And now look, he's doing it again. That's why this first case should not be allowed in. The second one is a Cobb County case from February 12, 2009. And in this case, again, Your Honor, we're not talking about a residence. We're not talking about a house or an apartment. We're talking about the burglary of an advanced cycle store where the people that went in, again, fled on foot, and the items that were taken were money and cigars. Again, we're not talking about elderly people. We're not talking about a residence. We're not talking about jewelry being pawned. We're talking about someone breaking into another business and taking money and cigarettes, basically. No similarities whatsoever. Again, this only goes towards, look, he did it not only in 2002, but he burglarized something in 2009. So look, he's going to do it again. There's no particular motive between breaking into the convenience store in Douglas County and advanced cycle store in Cobb County that shows the motive was for the same here. There's no evidence in the case in chief that Mr. Muckle or anyone broke through a window. There's no evidence that shows that Mr. Muckle or anyone went through a window. What the state told you, which is partially true, is that windows were open because the AC unit was not being used. However, they don't know if someone went through a window. They don't know if someone went through a door. They don't know what happened. And it's our position that somebody actually did have a key to that house and went through the door. And I believe the evidence will show that once we go forward. So that's why this second case should not be used, because it only goes to Mr. Muckle has burglarized something in the past, so he's a bad person. In regards to number 3, the Cobb County case from April 28, 2009, again, this was a burglary of a gas station. Same exact arguments for the first two. Again, the items that were taken, cigarettes, lottery tickets, I think, and some T-shirts. Once again, there are no similarities between the Cobb County case from April 28, 2009 and the case in chief for all the arguments I've made for the first two. And so I'm not going to go over those again. I'm going to have case law that goes towards that as well. Now, this fourth case is a Cobb County case from February 27, 2011. Again, this is the burglary of not a residence, but another business. This time it's the Mableton Pharmacy on 5000 Floyd Road. Here, officers saw a male subject carrying a black trash bag. Suspect ran and was apprehended. The items taken, 55 bottles of assorted drugs. Again, nothing to do with a residence, nothing to do with jewelry, nothing to do with pawning anything. Nothing to do with anything that the state's going to present in its case in chief when we go to trial on this particular circumstance. Once again, this is nothing more than the state saying, look, he's burglarized all of these other places. He's a burglar. This is what he do. The state has to show you some type of specific motive that says that all of these are going to prove, because they said they're using it for motive. What's the motive from all of these? That this is the motive that he went to a house and killed 2 elderly people, strangled them, set them on fire, allegedly stole jewelry, and then pawned it all over the state of Georgia. There's no motive that comes from breaking into businesses with other people and stealing cigarettes and stuff like that. I believe that's all of them. Now, in regards to some of the cases that the state quoted, I'm going to flip to the motive one first, because now we're only talking about motive and not intent. For motive, the case stated in their notice, Whaley v. State, that's 334 Georgia App 701, 2017 case. Your Honor, basically in this case that the state quoted, Whaley and his fiance were arrested for creating 841 fake accounts, like fake account payable entries within a company that they worked for. Basically what they were doing was they created this fake account. They funneled, I believe, over $800,000 from the company into their own account. And then they used that account or those accounts to basically pay off everything that they wanted to do in their lives, live a good, lavish life without actually working for it. Now, the 404B that the state brought in under Whaley was the state wanted to admit Mr. Whaley's 2005 guilty plea where he stole computer equipment and had to pay restitution. Now, the reason the state or the judge let this 404B in is because the court found he opened one of the fake accounts right before he took a plea, which he used to personally pay the restitution that he had. Now, that was the motive. He opened that account to use that money to pay restitution. That was clear motive in this case. I mean, that's what the court said. It's dispositive to this case, Your Honor, our case in chief, because that prior case was directly linked to something other than Mr. Whaley stealing money. It was linked to him stealing the money and using the money, his motive, use the money to take care of this. Again, the state hasn't shown you what particular motive breaking into gas stations and pharmacies and stealing drugs, pills, cigarettes, and money has anything to do with breaking into an elderly person's home, which the state even told you at the beginning looked like it was empty at first, and then killing two people and leaving. A case I would like to bring to the court's attention is Amy v. State. That's a 331 Georgia App 244. It's a 2015 case, and Amy is spelled A-M-E-Y. Now, in this case, the court took the position that a prior armed robbery is not admissible because it was not, or the prior armed robbery the state tried to introduce was not admissible because it was not sufficiently similar to the charged offense of armed robbery in the case in chief. The court says, here, the state asserts that the evidence makes clear that the motive for the instant and the prior crime was to gain money because the appellate demanded money from both women. But the fact that the accused has committed one crime or one kind of crime in the past does not, without more, prove his motive to commit the same kind of crime again. Such logic would make all prior robberies admissible in any robbery case, all prior murders admissible in any murder case, and so on. Basically, that's what we have here. The state saying because Mr. Muckle has been convicted of burglaries in the past, burglary plus burglary equals burglary. And it's little more than just a word matching game when it comes to 404B or any type of priors. I'd also like to point to the court's, let's see. Yes, another case I would like to point for the court's consideration is Heard v. State. That's H-E-A-R-D v. State, and that's 309 Georgia 76. It's a 2020 case. The facts of this case were appellant and others used a stolen vehicle, which they got from the Four Seasons Apartments to commit a robbery that ended in a murder, and the gun used in that murder was a .380. Afterwards, the stolen vehicle was found and burned a mile away from the apartments that they stole it from. The state introduced, in this case, evidence where the same appellant, 2 months after the murder, committed a carjacking, drove to Gwinnett County and stole a woman's purse using a gun as well. The appellant then set that vehicle on fire a mile away from the Four Seasons Apartments again. In this holding, the state said, the state argued that the latter act and present act both had a stolen vehicle, which was later abandoned and burned. The court goes on to note that even though both vehicles were stolen in the same general vicinity and they are abandoned in somewhat other locations, however, the similar features of both crimes are undermined by the major differences between the crimes. In one case, they steal a car, rob somebody by gunpoint, don't leave the area, and then burn the car. Another case, they steal a car, go all the way out to Gwinnett County, rob somebody out there, come back and burn the car again. And then the court said, well, there needs to be more similarities. This isn't just a matching game going back and forth. And I believe there's one more case I would like to present to the court. Actually, that newer case will take care, the Supreme Court case will take care of it. So basically, Your Honor, the state has to do more than just tell you that he's been convicted of something in the past. They have to show in their own words that this is being used for motive, and what particular motive did Mr. Muckle gain or have in the prior cases that shows that this is why he did it in this case. I would like to address the facts when the court was asking the state questions about the jewelry and the reason the state said the passage of time is why they couldn't find the jewelry. Well, Your Honor, when we go to court, the state may present witnesses to say, yes, these two people wore jewelry often. That's not really something that I can cross them on to where I'm going to get much information. The issue is those witnesses, from what I can tell, looking at the evidence, there are no receipts that said when this jewelry was purchased. There's really no description other than they're going to say, well, this is what the jewelry looks like. There are no serial numbers that says this is the bracelet, this is the watch, this is the ring. And furthermore, Your Honor, we have been doing this a very long time. All of us knows that if you go to a pawn shop and you pawn anything, there's some type of receipt that comes back with it. And usually they put it in the pawn system. We don't even have that evidence here. So when the state's trying to put the position that they're going to say that evidence or Mr. Muckle pawned jewelry around this time, well, there's also going to be evidence that Mr. Muckle has been pawning jewelry literally as long as he's been an adult. And there is a record of that. So simply because he pawned jewelry at the time without more, there's still no motive that goes to why, or there's still no particular motive that these priors show other than the fact that he burglarizes people. And for those reasons, we're asking that you keep everything out.
Everything meaning all four?
Yes,
burglaries.
I'm sorry, all four priors. Yes,
Okay.
Your Honor.
Got it. Thank you. Mr. Abate, I've got your brief, so I'll read through all that. I skimmed it just so we could have this discussion, but I do see the citation to Whaley and a few others. Anything you want to add in response to what you heard from Mr. Hoover?
Only that Mr. Hoover mentioned the fact that the windows were open and I guess the theory of the case from the state would be that the house was unoccupied, or that was the thought, which is why somebody went into it. Well, that is incredibly similar to all four of the incidents in which the defendant committed and was convicted of the burglaries, in the sense that in all four of those instances, the dwelling or the business was unoccupied, and which is why the defendant went into that business and stole the items from each one of the commercial residences, Your Honor. I would further, submit to the court that the defendant had the intent, or excuse me, the same motive when he entered into the residential home in this case. But unlike the other cases, he had never encountered anyone. In this instance, he had encountered two elderly people, and due to the fact that he encountered them as he was intending to steal their items, he then strangled them and lit the house on fire, would be the state's theory of what occurred that night. So I understand the arguments of counsel, and I can provide the court as well with additional case law, the court and counsel after this hearing.
All right. Excellent. I'm glad we covered that as well, because then all that we have remaining will be the 702 Daubert hearing, May 12th, 2 p.m. It'll just be a day later than you thought it was going to be, Mr. Abate. So you were going to be ready anyway.
Yes, Your Honor.
Get an extra day to be ready. If for some reason you learn that Detective Liam Packer is going to be like on SpaceX and actually can't be here, let us all know in advance, not just the night before, because there are a couple other dates later in the month, but I'd like to lock this down so we can get Mr. Muckle's case back on a trial calendar.
He's available the 11th, so I'm assuming that would mean the same for the 12th.
All right, well, please do double check today when we free you up. Anything else from the state?
No, Your Honor.
Mr. Hoover, anything else on behalf of Mr. Muckle?
Not today, no, Your Honor.
Okay, I'll get an order out on the motion to suppress the internet search history, as well as concerning the state's 404B notice, and that'll leave only the Daubert motion. Appreciate everyone's time, and we'll get you back here, Mr. Muckle, on the 12th, 2 weeks from today.
Yes, sir.
Thank you.
Thank you, Judge.
You're welcome.
And Judge, that completes my business. May I be excused?
You may. Thank you, Officer Brown. Thank you, Ms. Nelson.